maundu mara mothe mugathe arahĩtũkio matigwaga ona rĩo reciria ta mangĩgwa matigwaga to generally ambunge no mageragia muno kũhĩtũkĩria thirikari mijadala yao koguo nĩ gwagĩkinyire handũ makĩaga kũrũmĩrĩra mũtaratara ũcio wa parliamentary initiative makiuga no marũmĩrĩire mũtaratara wa popular initiative na hihi ndĩciragia guoya ũrĩa wokire hau nĩ kuona ta ũhoro ũyũ wa parliamentary initiative ũngĩaga ũkahĩtũkio nĩ ambunge angĩ nangĩ kana mage gũkinya 2/3 majority ĩrĩa ĩbatarĩkanaga na koguo gũkĩoneka hihi njĩra ĩrĩa njegega na ya raithi nĩ kũgeria kũrũmĩrĩra mũtaratara wa popular initiative
na popular initiative rĩ na rĩu haha menye mwambĩrĩria rũgongo mwacoka mamĩtwara kũrĩa kũrĩ tondũ ndĩreciria popular initiative yagire kumana na Wanjikũ oke naguo rĩu atũreheire no rĩu haha yambe igũrũ yacoka yathiĩ thĩ
rĩu nĩho gwakinyire andũ a civil society makiuga no twende kũria igoti tũria atĩrĩrĩ nĩ kwagĩrĩire mũgathe mũnene wa bũrũri atuĩke nowe president nowe executive no ũratongoria thirikari na ningĩ mũthenya ũmwe no okĩre atuĩke we nĩ raia ũngĩthiĩ kũrĩ raia amacainithie ma signatures arĩa matwarire cira ũcio igoti-inĩ makagiria atĩrĩrĩ mũndũ ũrĩa wagĩrĩirwo nĩ gũkorwo agĩka ũguo nĩ mũraia we mwene angĩkorwo nĩ arona maũndũ marĩa thirikari yagĩrĩirwo nĩ gũcenjia ndĩracenjia rĩ ena hinya na nĩguo ekĩtwo nĩ igoti akaheo hinya nĩ igoti wa gũgacoka gũthiĩ thĩinĩ wa igoti gũthiĩ kana gũcoka kwĩ mũingĩ acainithie ma signatures nĩgetha acainithie ma signatures maya rĩ makorwo makĩrorwo na njĩra ya gũgĩtindĩka executive macenjie watho kana nginyagia legislature macenjie watho nĩgetha ũthiĩ kũringana na ũrĩa raia arenda rĩu koguo mau nĩmo maũndũ marĩa matwarirwo for determination thĩinĩ wa igoti na igoti nene nĩguo rĩagĩtuire kiuga nĩ tuona mũnene wa bũrũri ndagĩrĩirwo nĩ kwambĩrĩria ũhoro ũcio na njĩra ĩyo ya popular initiative tondũ ena njĩra ĩngĩ angĩambĩrĩria nayo na gũgĩkorwo na matua kana orders iria ciakĩheanirwo irathiĩ gũkinya ngucĩro 13-14 na orders icio rĩ cigĩthiĩte ĩmwe kwa ĩmwe ingĩ igakĩhutia ũhoro ũcio wa mũnene wa bũrũri nginya kũ gazette committee ĩrĩa gazetire igacoka nacio ingĩ igagĩthiĩ ikahutia maũndũ megiĩ IEBC na hihi ndĩreciria mũthenya wa ũmũthĩ cira ũgĩgĩtuo hihi hau ha IEBC wahota kũrora igoti rĩa appeal rĩkĩregeria
haya
thĩinĩ wa mwĩcirĩrio wakwa
tondũ mahota kwambĩrĩria tene gũkĩra tũreciria rĩ nĩguo itua rĩrĩ rĩngĩthiĩ rege rũgame rĩ no ngĩ benefit mo no ngĩgua fiu niĩ nĩ ndagunĩka makĩria na rĩngĩ tiarĩ BBI ĩrwo nĩ gũthiĩ na mbere kana rege ĩrwo nĩ gũthiĩ na mbere rĩ no ngĩ benefit mo no kũigua gunĩka mũno na itua rĩu
kĩũria kĩu na mũthikĩrĩria witũ nake no acokie onake no atũcokerie no tũmũrie kĩũria kĩu na njĩra ĩngĩ tũmũrie atĩrĩrĩ mbere ya ũhoro ũyũ ũkinye thĩinĩ wa igoti rĩ no watindĩkaga mũno ũhoro wa BBI na no wareganaga mũno na ũhoro wa BBI so in the first place akorwo mũndũ nĩ areganaga mũno na BBI rĩ ĩcoke ĩgwe rĩ ndũgũkĩona ina way nĩ akuoneka ta arahotana ndikana wanyita automatically nĩ akuonekana ta arashinda na ũndũ ũrĩa ũngĩ naguo rĩ arĩa matindĩkaga BBI mena meciria ma gũkorwo makĩgĩa na itĩ mangĩhota kũgayania harĩa igũrũ rĩ hihi tuge ta mũndũ ta Raila Odinga rĩ BBI ĩcoke tuĩke nĩ ya gwatha ici rĩ itĩ icio megũcoka magayania atĩa tondũ wĩna andũ harĩa mũrĩ andũ mũgwanja harĩa igũrũ na mũrehokete BBI yũke we woe kia deputy president nawe woe kia prime minister nawe woe kia deputy prime minister nake deputy prime minister nake ũguo mũracibangĩte hau ũguo rĩ rĩu BBI nĩ yehera ũracoka ũnjĩre mekũgayania itĩ icio atĩa kũngĩtuĩka atĩ BBI ndĩnahĩtũka mangĩcoka magayania atĩa mangĩoya ta rĩu tuge akorwo nĩ ta Raila Odinga watuĩka magĩtĩ kĩa president rĩ angĩcoka oe deputy wake atĩa na tondũ hihi Mount Kenya no nginya marĩtindĩka biũ make sure mũndũ ũrĩa ũrĩrũgama harĩa igũrũ nowe ũrĩkorwo no nginya oe deputy kuma Mount Kenya rĩ ũngĩrora mũtaratara ũrĩa Raila Odinga naguo harĩa igũrũ andũ arĩa nao mũgwanja kana 8 andũ aya aoka na rĩmwe nĩ marakinya handũ makauga marenda oka ĩthire o ta ũrĩa Nasser athirire nĩgetha mathondeke nyamũ ĩngĩ ĩretwo BBC Building Bridges Coalition na ndiĩ kana BBI yagwa Building Bridges Coalition nĩ gũkorwo ĩkĩrĩ njega tondũ ĩnyitithania na rĩtwa rĩa ũndũ ũragũire rĩ yahota gũkorwo ĩhana ta kũgwa koguo andũ arĩa marĩ harĩa oka na Nasser rĩ na andũ 8 rĩ hatirĩ na mũgĩkũyũ ũrĩ hau kana arĩ ho
no tukige Uhuru na ndarakĩrũgama hatiri mundu wa Mount Kenya hau
hatiri mundu wa Mount Kenya hau hatiri mundu wa Miruga na Embu kungicoka gutwike ati ni matindikwo ni mugathe president tondu njui president ona akimera manyitane hana ndangimera manyitane oro uguo ati aigite Mount Kenya nja ya equation ye
we mundu ringi ohithitwo he giako kiithe
no nginya ngiarirehe mundu wa Mount Kenya amarehera mundu wa Mount Kenya ri mundu uyu agacoka aingirire ha atigia yange nja tuge ni mundu gwitwo Raila Odinga wa kirugama atige Kalonzo arehe mundu wa Mount Kenya atuike deputy wake
atige Mudavadi ko na atige mundu gwitwo Wetangula ko atige Gideon ko na atige mundu gwitwo
na gwiraga muno ndukagwite horo wa Wetangula na Gideon muno tondu acio constituency yao ni thingithie muno mundu ungibatara korwo hau muno ni Kalonzo ucio na constituency na Raila Odinga well Mudavadi ti muno no
haya igicoa-ini nakio kiha
no akiriona ka constituency igicoa-ini ndu mundu gwitwo Raila Odinga ni ahotaga kuingira atari na atongoria ciangi
riu ko guthira cia raingatire ta Kingi ona Njoho
ni ahotaga kuingira atekumahũthĩra muno o kaundu nako karoneka pia deputy president na akiagika na nikio mekubatara ona kumwitigira makiria tondu deputy president nake ni arahota kuingira kuria gicoa-ini na akahota kuingira kuria Western Kenya o ta Raila Odinga ingiraga atekuhuthira atongoria cia kuu kau ni kaundu magukorwo magitigira muno
ndina ndikurenda ndita Kalonzo irrelevant
no generally mundu ta Kalonzo ndangitwika irrelevant na rua tondu mundu ta Kalonzo ena andu makoretwo thutha wake kwa ihinda iraihu muno na matire mamutiga
ari aru wafuasi
yake unlike mundu ta Wetangula na Mudavadi uria udairiutagwo muno
na magiuka ni tondu ni magiuka kuri we tondu kiria uramane
that is it ruko guo mundu ta Kalonzo ucio ni agutigwo bado akiri ona hinya wake na kiria riu kuona na niguo ndireciria kuri ikara thutha-ini ri either some of those people ni maregeria guthi gwetha uria mangenyitana na William Ruto na kwa William Ruto nako gutirakioneka kwina space nene muno tona ke William Ruto no ndarenda uhoro ucio wa baggage nene
na arekaga mathabu make gutari BBI
we arekaga mathabu make gutari BBI na ndarenda uhoro ucio wa atongoria cia ingi tondu we arenda muno guthie directly kuri mwananchi na niguo akoretwo akiuga
ngathiti kwandikite atiriri ati BBI ingithie na mbere ri no advantage kuri we ona gutuika ni kumuhe gatagi karia kariri urenda gegwa na ndinagwa no muno ni ndu wa kugaya ituro icio wa njira ri Ruto no nge benefit more
ina we ni akubenefit makiria na njoke njuge kira ndireciria kiricoka giikare thutha-ini ni ati ni kuri korwo na kiru gitagwo third force ni kuri korwo na Raila na mundu wa Mount Kenya na gucoke gukorwo na mundu gwitwo Ruto na mundu wa Mount Kenya gucoke gukorwo na Kalonzo hihi na Mudavadi
acio ndurona ta magikara mwena wa Raila
ni megutindikwo maikare mwena ucio no mwisho wa uhoro ri wahota kuona makigeria gwetha njira ya ku justify presence yao thiini wa siasa through andu wao tondu ona no marikiorio ru Kalonzo no marikiorio ni andu akwa atiriri kai na yo gituro ukirio deputy na yaite tutanyitaga Mudavadi nake ni urona ni aregire nginya kuingira thirikari-ini ino nigetha eterere agatuika president na riu no weredia no ga step down yori ongi dino wa ituika presidential candidate no ongi atuike deputy
ni makeheranira
riu hau hena thina koguo BBI igituika ndina thie through ni kurecoketie na thutha murengo ucio kundu kuraihu muno ni tondu wogai wa mahinya undu ronge naguo ukorwo ugicoka na thutha muno kana ukirehe ngahiha ni ati BBI no iretagiririrwo kuriukia andu aingi aria marauma siasa-ini magavana maria marauma ite-ini ciao marikitie miaka yao 10 ta Mutua andu ta Kivuza Kibwana Wairia andu ta wa Bora
actually iko na mugwanja gucio mararikia
ara mararikia wira wao thaici wa governor ri ni kureciragirio ati BBI ni kumateithiriria nigetha iti cia bunge ituike nicio ikarutaga ma MP amini nicio ikarutaga ministers na assistant ministers iko aigao ni maranoraga ni meguthi kurugama iti cia ma MPs ni maranoraga ati ona no cikaruta nginya prime minister koguo andu aingi ni marenda guthi kurugama ma MP nigetha either mundu ethe giti kia prime minister kana ethe giti kia waziri riu ni ura imagine BBI yagwa ni kuga riu giti kiria kia bunge uria kingiratuikire attractive ni giatiga gutuika attractive ya ni uronire rita riri ona andu aingi aria macagurirwo bunge ora ti andu moekaine aigona ti andu ona mari mamenyeka ona umuthi uyu tondu generally giti kiu gitia kurirwo kina attraction ne itanga cia siasa na andu aria mega tu thiini wa siasa
itanga cia dire senate
na governor riu koguo ni mareciragiria ati no meke atia na nikio urona bado mundu ta Kĩonia kĩgeria gũcokia kawatho kangĩ harĩa thutha gakuga atĩ no introduce watho ũcio rĩngĩ mbunge separately.
Thank you mũno. Kĩtambe tũthiĩ kũrĩa igoti-inĩ twambe tuone o ndagĩka cici twambe tuone nĩatĩa kũrathiĩ na mbere, na ngwĩciria gũkwagĩrĩire kwanjĩrĩria thaa 3:00. Reke twambe tuone nĩkĩ kĩrathiĩ na mbere o hanini nĩgetha tuone nĩatĩa. Na ngwĩciria atĩrĩrĩ wakiri, reke tũrĩkĩrie hau tondũ ndĩrona tarĩ kwambĩrĩria kũrambĩrĩria, na ti ta kwambĩrĩria kũrambĩrĩria, nĩ itua rĩu rĩa BBI, nĩ itua rĩranda gũthoma rĩu ndathiĩ kuo ndagĩka wega wakiri tũkwaria mũthenya ũngĩ tũthiĩ ĩmwe kwa ĩmwe nginya igoti-inĩ rĩrĩa gũcokia cira riko nĩgetha tuigue nĩ atĩa kũrathiĩ.
And all Kenyans who are virtually attending this court session. This court is now in session for delivery of the judgment in civil appeal number E291 of 2021, the Iebc versus David D. and others, as consolidated with 7 other appeals, as shall soon be called out. My name is Justice Daniel Musinga, and sitting with me are the Honorable Lady Justice Nambuye, the Honorable Lady Justice Okwengu, the Honorable Mr. Justice Kiage, the Honorable Mr. Justice Gatembu, the Honorable Lady Justice Ichale, and the Honorable Mr. Justice Tuyot. The delivery of the judgment shall take a fairly long time, because each judge has written their own judgment and shall read it personally. None of us shall however read their judgment in its entirety, and because it would take the whole day if we were to do so. We shall each read what we consider the most important parts of the judgment, but will provide soft copies of the same shortly after the end of the session. At 11 a.m. or thereabout, we shall adjourn for a 20 minutes health break and continue thereafter until about 1 p.m. If we shall not be done by then, we shall adjourn for lunch for 1 hour and finalize the remaining part thereafter. I urge all of us to strictly observe the COVID-19 mitigative protocols by putting on masks throughout the session and maintain the requisite social distance. I now request the head court assistant to call out the appeals.
Civil Appeal Number A291 of 2021, Independent Electoral and Boundaries Commission versus David D. and 81 others.
Now, regarding the quorum, I suggest that you introduce yourselves very quickly. If there are other counsel who are assisting you, one of you may introduce them so that we do not take a very long time during that exercise. Thank you.
Good morning.
Good morning.
My name is Kennedy Ogeto, appearing for the Attorney General of the Republic of Kenya. With me, the Senior Counsel, George Oraro, who is in court, Mr. Kamau Karobi, who is following the proceedings virtually, Mr. Paul Nyamodi, also following the proceedings virtually, Mr. Donald Kipkori, and Mr. Emmanuel Mitchell. For the BBI Secretariat and the Honorable Raila Odinga, Senior Counsel Orengo, and Dr. Chenamolo, Senior Counsel, Musi Kampudi, Senior Counsel, all in court, Paul Mwangi, Professor Ben Sihanya, and Jackson Awele. For the Iebc, Mr. David Negai, Senior Counsel, following the proceeding virtually. Mr. Eric Bongo, present in court. Mr. Justice Munyedia, in court. Mr. Moses Kipogay, following the proceeding virtually. Mr. Ken Menon, Mr. Maboy Mugai, and Mr. Ochen Wasonga, following the proceedings virtually. For His Excellency the President, Uhuru Kenyatta, Mr. Olegu Gatonye, Senior Counsel, President in Court, Mr. Kiramu Kimani, and Mr. Mohamed Kaura, all of them present in court. Thank you.
Thank you, Mr. Ogeto. So I will read the... Oh, sorry, where are the counts of the respondents?
May it please you, the President, the Court of Appeal, my lords and my ladies, my name is Nelson Harvey. I appear together with Ms. Esther Amara for the first and the fifth respondents.
Good morning, my ladies and my lords. My name is Elias Mutuma. I appear for the 19th, 20th, and 21st respondents alongside Professor Kidore Kindike, who is attending virtually, and Caroline Leon, who is attending in court. Thank you.
Please support Amata Karwa appearing in Zoni Mibuto for the 11th, 12th, and 13th respondents.
For the 14th respondent, my lord, it's Ochiel Dudley with Mr. Ian Mabenge, who is virtually attending. Thank you.
May it please the court. My name is Edgar Busiaga Mwanga, appearing for the Kenya National Union of Nurses, the sixth respondent. I'm appearing with Sifrin Mayende, who is appearing.
May it please the court, my lords, my lady. My name is Ndegwa Njiru. I appear for the 47th respondents.
My lords and my ladies, in the matter, my name is Kuyoni. I appear for the 7th respondent.
May it please the court. Good morning. My name is Njoki Mboshe. I appear with my brother Dome Obura and Michael Ngure for the 45th respondent.
May it please the court. My name is Wambulua. I appear for the 8th respondent, the Senate.
Good morning, Your Lordships. My name is George Gilbert. I appear for the 71st respondent. Thank you.
Good morning, Your Ladyships, Your Lordships. My name is Evans Ogada. I appear alongside Mr. Elisha Ongoya, who is appearing virtually. Thank you.
Good morning, Mr. President, my lords and my ladies. My name is Morara Omoke, the 76th respondent, appearing with my legal team, which is attending virtually, Mr. Gilbert Nyamwea, Vincent Mulondo, Dr. Mudomi Thiangolu, and Topoa Lesinko.
Good morning. My name is Muhui Mwaniki. I appear alongside my senior, Ms. Carolyn Kituku, for Muhuri, the 26th respondent.
May it please the Honorable Court, my name is John Khamenua. I appear for the 9th respondent with Valentine Khamenwa, and I also appear for Kituo cha Sheria 10th respondent with my other friend, Mr. John Mwarede.
May it please you, my Lord. My name is Dr. Eboso. I appear as the 76th respondent. 254 Hope.
Is there anyone who has not introduced themselves? All right. I will now read the introductory part of my judgment, after which my brother Justice Tuyot will take it out from there, and we follow in the order in which we introduced ourselves earlier. That the Constitution of Kenya 2010 is a transformative one has never been in dispute at all. Its implementation has, however, not been without considerable challenges, mainly because of competing interests among three categories of Kenyans: the holders of political power, aspirants for political power, and the majority of Kenyans who are apolitical and whose foremost interest is to see that all the affairs of this country are well handled, irrespective of who wields political power. The Constitution declares that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with the Constitution. The people of Kenya have delegated their sovereign power to Parliament and legislative assemblies in the county governments, the national executive and the executive structures in the county governments, and the judiciary and the independent tribunals. The judiciary has been given constitutional mandate to arbitrate political, social, and economic disputes among the people or among the three arms of government. It is required to do so by way of diligent and honest interpretation and application of the Constitution and the laws of the country. These appeals are basically about the interpretation of three articles of the Constitution, 255, 256, and 257, that form Chapter 16 of the Constitution. The appeals arise from the judgment of the High Court sitting in Nairobi, dated 13th of May 2021, in Constitutional Petition number E282 of 2020, consolidated with 7 other constitutional petitions, numbers 397 of 2020, E400 of 2020, E401 of 2020, E402 of 2020, E416 of 2020, E426 of 2020, and 2 of 2021. Each of the petitioners challenged various aspects of the Constitution of Kenya Amendment Bill 2021, hereinafter the Amendment Bill, and the process that preceded the crafting of the bill. The background is as follows. On 9th of March 2018, President Uhuru Kenyatta and the former Prime Minister Raila Odinga, who had come out of a bruising presidential election contest, decided to bury their political differences that were evidently causing considerable discord in Kenya and came together with the aim of uniting the country. In a symbolic handshake, the two leaders set in motion various events that were aimed at moving the country forward. The President and the former Prime Minister released a joint communique known as Building Bridges to a New Kenya Nation. The communique contained 9 issues that affected our country, and these are ethnic antagonism and competition, lack of national ethos, inclusivity, devolution, divisive elections, safety and security, corruption, shared prosperity, and responsibilities and rights of citizens. In order to address the identified issues, on 31st of May 2018, the President, by Gazette Notice number 5154 of 2018, appointed the Building Bridges to Unity Advisory Task Force, the BBI Task Force thereafter, to document and recommend practical policy and administrative reform processes that would build the country's lasting unity and the implementation modalities for each identified challenge areas. The terms of reference of the BBI task force were as follows. A, evaluate the national challenges outlined in the joint communique of BBI to a new Kenyan nation, and having done so, make practical recommendations and reform proposals that build lasting unity. B, outline the policy, administrative reform proposals, and implementation modalities for each identified challenge area. And C, conduct consultations with citizens, the faith-based sector, cultural leaders, the private sector, and experts at both the county and national levels. The BBI task force visited all the counties in Kenya and collected views from more than 7,000 citizens from different ethnic groups, community leaders, religious institutions, to name just but a few. On 26th of November 2019, the BBI released its report on what is known as, quote, building bridges to a united Kenya from a nation of blood ties to a nation of ideals. In short, it's referred to as the BBI Task Force report. On the following day, the report was unveiled to the public, and the public public engagement thereon kicked off. The BBI Task Force report came up with various policy and administrative reform recommendations which enabled constitutional amendments, policy reforms, statutory enactments, institutional reforms, as well as behavioral and ethical changes amongst the citizens. To actualize their foresaid recommendations, the President, by Gazette Notice number 264, dated 3rd January 2020, and published in a special issue of the Kenya Gazette dated 10th of January 2020, appointed a steering committee known as the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report. The mandate of the steering committee was twofold. Number one, conduct validation of the BBI Task Force report through consultations with citizens, civil society, faith-based organizations, cultural leaders, the private sector, and experts. And two, propose administrative, policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendations contained in the BBI Task Force report, taking into account any relevant contributions made during the validation period. The BBI Steering Committee held a number of stakeholder consultation meetings and received memoranda from members of the public and organizations, and on 21st of October 2020 presented its report known as the Report of the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report. The report recommended various constitutional, legislative, policy, and administrative measures. The BBI Steering Committee also came up with a draft Constitution of Kenya Amendment Bill 2020. The recommendations made by the BBI Steering Committee and the draft Constitution of Kenya Amendment Bill 2020 were viewed by various stakeholders and members of the public as unconstitutional for various reasons that I will highlight hereafter. To accommodate those concerns, some amendments to the draft bill were made, and the final Constitution of Kenya Amendment Bill 2020 was printed by the government printer on 25th of November 2020. The aforesaid amendments did not stop various petitioners from moving the High Court in 8 petitions to challenge the process by which the amendment bill was formulated and the contents thereof. They argued that they were unconstitutional. The following petitions were instituted. Number 1, petition number 2, E282 of 2020, David D. and others versus the Attorney General and others. 3 main issues were raised in this petition, namely, A, whether the legal and judicial doctrine of the basic structure of a constitution, the doctrines of constitutional entrenchment clauses, unamendable constitutional provisions, and constitutional amendments, the theory of unamendability of the Constitution, essential features in a Constitution, and the implied limitations of the amendment power in a Constitution are applicable in the Republic of Kenya. B, whether Chapter 1 on sovereignty of the people and the supremacy of the Constitution, Chapter 2 on the Republic, Chapter 4 on the Bill of Rights, Chapter 9 on the Executive, and Chapter 10 on the Judiciary, and the provisions therein form part of the basic structure, entrenchment clauses, and eternity provisions of the Constitution, and therefore cannot be amended either under Article 256 by Parliament or through popular initiative under Article 257 of the Constitution, and C, whether taking guidance from the doctrine of the basic structure of the Constitution, the constituent power, and the doctrines of unconstitutional constitutional amendments, the limits of the amendment power in the Constitution, and the theory of unamendability of the eternity clauses, there is an implied or implicit limitation to powers of constitutional amendments under Articles 256 and 257 of the Constitution. Dr. Duncan Oburu Ojwang, Dr. John Osogo Ambani, Dr. Linda Andisi Musumba, and Dr. Jack Busalile Mwimali, law professors, were admitted as amici curiae, and they advanced similar arguments as the petitioners in petition number E282 of 2020 regarding the basic structure doctrine, the limits of the constituent's power, and the role of the courts in interpretation of the Constitution, among others. Number 2, petition number 3E397 of 2020, Kenya National Union of Nurses versus Steering Committee of BBI and others. The petitioner urged the court to determine whether the task force on building bridges to Unity Advisory Committee was duty-bound to include an independent and constitutional health service commission in its October 2020 report. The petitioner sought 3 orders. 1, a declaration that the omission of the petitioner's proposal for an independent and constitutional health service commission in the October 2020 report of the task force on building bridges to Unity Advisory offends Articles 10, 27, 41, 43, and 47 of the Constitution of Kenya, and the task force on building bridges Unity Advisory be compelled to publish a fresh amendment bill to include the same. B, a declaration that the Iebc be prohibited from conducting the preparatory process towards the approval of the amendment bill and submission of the same to a referendum. C, an order that Parliament be restrained from receiving and passing the amendment bill. The third petition was E400 of 2020, Third Way Alliance Kenya versus Steering Committee of BBI and others. The substantive issue raised by the petitioner was whether a popular initiative for the amendment of the Constitution of Kenya can be commenced by state actors, in particular the President of the Republic of Kenya. The petitioner further argued that a popular initiative in the amendment of the Constitution cannot be commenced and undertaken without a legal framework for the same. The petitioner sought the following reliefs. A declaration that the Constitution of Kenya Amendment Bill 2020 was not a popular initiative towards the amendment of the Constitution of Kenya. B, a declaration that there is no legal framework to undertake an amendment by way of a popular initiative, to wit, collection of signatures and their verification and conduct of a referendum. And C, a declaration that county assemblies have the power to amend the amendment bill, do not have the power to amend the amendment bill. Number 4, petition E401 of 2020, 254 Hope versus the National Executive of the Republic of Kenya. The petitioner herein urged the court to determine whether the National Executive or any state organ or entities can commence a popular initiative for the amendment of the Constitution of Kenya and utilize funds in the initiation and pursuit of the process. It is sought the invalidation of the entire process, resulting in the publication, approval, and passing of the amendment bill. The fifth petition was number E402 of 2020, Justice Juma and Isaac Ogola versus the Attorney General and others. The petitioners raised the question whether the creation of 70 constituencies by the by the promoters in the amendment bill was unconstitutional, since the function of delimitation of the constituencies is vested in the Iebc. They urged the court to declare as unconstitutional and annul the creation of the 70 constituencies in the amendment bill. The sixth petition was number E416 of 2020, Morara Omoke versus Raila Odinga and others. The petitioner raised the following issues. A, whether the Constitution of Kenya Amendment Bill 2020 can be submitted to county assemblies for consideration, tabled in Parliament for passing or rejection, and transmitted to a referendum in the absence of a legal framework for facilitating the same. B, whether the amendment bill can be transmitted to a referendum before a nationwide voter registration exercise. And C, whether the use of public funds by the President and Honorable Raila Odinga in the initiation and facilitation of the process culminating in the tabling of the amendment bill in Parliament is unconstitutional. And D, whether Parliament has power to act upon the amendment bill following the declaration of its unconstitutionality for want of enactment of the 2/3 gender laws and the advisory opinion by the Chief Justice to the President for its dissolution. The petitioner prayed that the court declares as unconstitutional and invalidates the entire process culminating in the publication of the amendment bill. Petition number 7 was E426 of 2020, Isaac Aluchier versus Uhuru Muigai Kenyatta and others. The substantive question raised by the petitioner was whether the President has power to initiate an amendment to the Constitution of Kenya in the manner relating to the amendment bill and to use public funds in such a process. He contended that the steering committee had converted an illegal presidential constitutional change initiative into a popular initiative. He sought a declaration on unconstitutionality and the invalidation of the entire process. Worthy of notice is that this petitioner sought certain declarations against the President in his personal capacity. And the last petition was number number 2 of 2021, Muslims for Human Rights, Muhuri versus Independent and Electoral Boundaries Commission and others. The main contention by the petitioner was that the IEBC cannot undertake verification of signatures and registered voters without an enabling legal framework in place, and sought a declaration to that effect. I'll now summarize the responses to these petitions. The Attorney General filed grounds of opposition raising a total of 12 grounds, which I shall summarize as follows. He stated that a declaration that the provisions founded under Article 255(1) of the Constitution forms the basic structure, entrenchment clauses, and eternity provisions of the Kenya Constitution and cannot be amended under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution would be against the express provisions of the Constitution, including Article 255(1), which will have been rendered odious. He added that the petition did not meet the established legal threshold of justiciability for want of ripeness, that the interpretation propounded by the petitioner runs contrary to the constitutionally prescribed purpose mode of interpretation by negating express purposes of Articles 255, 256, and 257 of the Constitution, and that any comparative analysis of foreign jurisprudence could not be used to either contradict or supplement the text of the Constitution of Kenya, that the petitioners were invoking an advisory opinion jurisdiction which the High Court cannot give. The Speaker of the National Assembly, who was the second respondent, raised 9 grounds of opposition. He concurred with the arguments advanced by the Attorney General with regard to justiciability and ripeness. In addition, the Speaker of the National Assembly contended that the petitioners were preempting how the National Assembly would exercise its mandate with respect to the amendment bill, and that the issues advanced could have been tabled before Parliament during public participation exercise as envisaged under the Constitution of Kenya 2010 and the standing orders of the House. The second respondent further argued that the High Court lacked jurisdiction to intervene in active parliamentary processes, and therefore any challenges to the amendment bill had to await the completion of the legislative process before the jurisdiction of the courts can be invoked to challenge the bill. The Speaker of the Senate, who was the third respondent, also filed grounds of opposition, raising 8 grounds. He reiterated the grounds argued by the Attorney General and the Speaker of the National Assembly. He stated that the people of Kenya have the sovereign right to amend the Constitution in the manner prescribed under Articles 256 and 257 of the Constitution. On their part, the BBI Secretariat and Honorable Raila Odinga filed consolidated grounds of opposition, raising 10 grounds, most of which were a replica of the grounds raised by the first, second, and third respondents. They also filed an affidavit that was sworn by Mr. Dennis Waweru, who stated that he was one of the co-chairpersons of the BBI Secretariat and its co-chairman was Honorable Junet Mohammed, that the Building Bridges Initiative was created and mandated with the task of initiating a constitutional amendment process and unifying Kenya among other functions. Mr. Waweru deposed that Article 1 of the Constitution of Kenya 2010 vests sovereign power to the people of Kenya, and such power is to be exercised only in accordance with the Constitution of Kenya 2010, that the Constitution is not a rigid document, and pursuant to Articles 255, 256, and 257, it can be amended as provided for in the said provisions, that if the framers of the Constitution did not intend that the Constitution be amended, nothing would have barred them from having such an express provision included therein. Regarding the doctrines and theories of basic structure, constitutional entrenchment clauses, and unamendable constitutional provisions as proposed by the petitioners, Mr. Waweru stated that they were mere theories and hypotheses only applicable in different jurisdictions and relevant depending on the special circumstances of each jurisdiction. The Iebc contended that in the exercise of its powers under Article 257, it enjoys constitutional and administrative, decisional, and financial independence, that it carried out its constitutional mandate of verifying that the constitutional amendment initiative was supported by at least 1 million registered voters, that it was erroneous for the petitioners to argue that there was no legal framework for verification of registered voters, as the provisions of Article 257 made it possible for the actors to know their obligations, and therefore there was no basis of making any finding against it. For making any finding against it. In respect of the petition by Mr. Isaac Alucher challenging capacity of the President to initiate a popular initiative for amendment of the Constitution, the President did not respond to the petition at all. However, the Attorney General filed grounds of objection, stating in the earlier that the President, Uhuru Muigai Kenyatta, cannot be sued in his personal capacity for any acts done during the pendency of his presidency, that the issue of constitutionality of the President's functions is res judicata, and that monies expended on the President's constitutional functions could only be audited by the Auditor General. The court could not be involved in such an issue. Having perused lengthy affidavits, written submissions, copious authorities, as well as oral submissions by counsel, the High Court made the following declarations. A, that the basic structure doctrine is applicable in Kenya. B, that the basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. In particular, the basic structure doctrine limits the power to amend the basic structure of the Constitution and eternity clauses. C, that the basic structure of the Constitution and eternity clauses can only be amended through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collation of views, constituent assembly debate, and ultimately a referendum. 2, a declaration is hereby made that civil court proceedings can be instituted against the President or a person performing the functions of the office of President during the tenure of office in respect of anything done or not done contrary to the Constitution. 3, a declaration is hereby made that the President does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 4, a declaration is hereby made that the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette on 10th of January 2020 is an unconstitutional and unlawful entity. Number 5, a declaration is hereby made that being an unconstitutional and unlawful entity, the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report has no legal capacity to initiate any action towards promoting constitutional changes under Article 257 of the Constitution. Number 6, a declaration is hereby made that the entire BBI process culminating with the launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. Number 7, a declaration is hereby made that Mr. Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. Number 8, a declaration is hereby made that the entire unconstitutional constitutional change process promoted by the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report is unconstitutional, null and void. Number 9, a declaration is hereby made that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum before the Independent Electoral and Boundaries Commission carries out nationwide voter registration. Number 10, a declaration is hereby made that the Independent Electoral and Boundaries Commission does not have quorum stipulated by Section 8 of the Iebc Act, as read with paragraph 5 of the second schedule to the Act, for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution of Kenya Amendment Bill and Article 257(4) of the Constitution submitted by the Building Bridges Secretariat. Number 11, a declaration is hereby made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor a legal framework to govern the conduct of referenda. Number 12, a declaration is hereby made that the absence of a legislation or legal framework to govern the collection, presentation, and the verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed. Number 13, a declaration is hereby made that county assemblies and parliament cannot, as part of their constitutional mandate, to consider a Constitution of Kenya Amendment Bill initiated through a popular initiative under Article 257 of the Constitution, change the contents of such a bill. Number 14, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to predetermine the allocation of 70 constituencies, is unconstitutional. Number 15, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to direct the Independent Electoral and Boundaries Commission on its function of constituency delimitation, is unconstitutional. Number 16, a declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to have determined by delimitation the number of constituencies and apportionment within the counties, is unconstitutional for want of public participation. Number 17, a declaration is hereby made that administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null and void because they were made without quorum, in the absence of legal authority, and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the Statutory Instruments Act 2013. Number 18, a declaration is hereby made that Article 257(10) of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. Number 19, a permanent injunction be and is hereby issued restraining the Independent Electoral and Boundaries Commission from undertaking any processes required under Article 257(4) and 5 in respect of the Constitution of Kenya Amendment Bill 2020. Number 20, the prayer for an order that Mr. Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report established by Mr. Uhuru Muigai Kenyatta is declined for reasons that have been given. Number 21, the prayer for the orders that the Honorable Attorney General to ensure that other public officers who have directed or authorized the use of public funds in the unconstitutional constitutional change process promoted by the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report made good make good the said funds is declined for the reasons that have been given. 22. The rest of the reliefs in the consolidated petitions not specifically granted are deemed to have been declined, and on cost, this being a public interest matter, parties shall bear their own costs. Those were the orders that were made by the High Court, from which the 4 appeals that I read earlier were raised. The Iebc, in its memorandum of appeal, raised 12 grounds of appeal, which I will summarize as hereunder, that the learned judges of the High Court erred in law in finding that the appellant lacks the requisite quorum for purposes of carrying out its constitutional and statutory mandate in relation to the intended appeal in the interpretation of the role of the appellant to verify that the initiative is supported by at least 1 million registered voters under Articles 257(4) of the Constitution, and instead misconstrued the provision to mean verification of signatures. In finding that the provisions of Article 257(4) require a special framework for verification of signatures. In finding that the administrative measures put in place by the appellant to verify that the constitutional review initiative is supported by at least 1 million registered voters are invalid. The Iebc also faulted the learned judges for finding that the appellant ought to have carried out a nationwide voter registration exercise for the purpose of the intended referendum, for misconstruing the process of certification of the register of voters under Section 6 and 6A of the Elections Act with the requirements for continuous voter registration under Section 5 of the Elections Act, for finding that the appellant had an obligation to ensure that the promoters of the bill had complied with the requirements, public participation before transmitting the amendment bill to the county assemblies. And the Iebc further faulted the learned judges of the High Court for misapprehending the place of public participation in relation to constitutional review process by way of popular initiative, for failing to take note of its jurisdictional scope, for delivering a judgment that is internally incoherent, contradictory, and inconsistent, for granting orders which threatened the usurpation of the functional independence of the appellant, and for failing to appreciate that the evidential threshold for granting the declaratory reliefs had not been satisfied by the petitioners, and consequently arriving at the wrong conclusions. In Civil Appeal number 292 of 2021, this is the Building Bridges to United Kenya National Executive and another versus David D. and others. The two joint appellants, through Paul Mwangi and Company advocates, raised a total of 19 grounds. I'll just summarize a few of them. In summary, they faulted the learned judges for misapprehending the factual matrix relevant to the constitutional amendment initiative, for finding that the basic structure, eternity clauses, and unamendability doctrines are applicable under the Constitution of Kenya 2020, for introducing an extraneous mandatory and exclusive four-sequence process unknown under the Constitution of Kenya 2020, for imposing on the promoters of the amendment bill obligation to conduct nationwide public participation exercise prior to collection of signatures in support of the constitutional amendment initiative, for elevating the provisions of the Independent Electoral Boundaries Commission Act above Article 250 as read with Article 2 sub-Article 4 of the Constitution, and for misapprehending Article 257(4) and thereby unconstitutionally and unlawfully imposing a non-existent duty and or criteria for the verification of signatures. There are several other grounds that I will not read. In Civil Appeal number 293 of 2021, the Attorney General versus David D. and others, in his Memorandum of Appeal, the Attorney General raised 31 grounds, and I'll pick a few of them, that the learned judges of the High Court erred in law by finding that the basic structure doctrine applies to Kenya, for holding that the basic structure of the Constitution can only be amended through the exercise of the sovereign power of the people in the exercise of their primary constituent power, and not as contemplated under Articles 255, 256, and 257 of the Constitution, by finding that certain provisions of the Constitution are insulated from amendments and thereby classifying them as eternity clauses, by admitting and vividly relying on submissions of purported amicus curiae that were partisan, by holding that the amendment bill was not in tandem with an amendment of the Constitution by popular initiative as provided under Article 257 of the Constitution, in misinterpreting the role of the President and the Executive in the process in the process leading to the amendment bill, in holding that the power to amend the Constitution through the popular initiative route is reserved for private citizens, by misinterpreting Article 257 with regard to the persons or entities that can promote amendments to the Constitution, and holding that the BBI National Secretariat could not promote a constitutional amendment, by holding that the BBI process was not in compliance with Articles 10 and 33 of the Constitution, and in failing to appreciate that the amendment bill was subjected to all processes and motions contemplated under Article 257 of the Constitution. Civil Appeal number E294 of 2021, Uhuru Muigai Kenyatta versus David Ndii and 82 others. The appellant, through Mr. Waweru Gatonyi and Company, raised 17 grounds of appeal, and I'll summarize some of them. He contended that the learned judges erred in law and violated or acted contrary to the rules of natural justice by making a decision adversely affecting the appellant and without hearing him, contrary to the provisions of Articles 27, 50, and 159 of the Constitution, by failing to find that the respondents, as petitioners in petition number E426 of 2020, having joined the appellant as a party to the petition, elected not to serve the said petition on the appellant, and further elected to abandon the suit or further proceedings against the appellant in the, I'll take that again. Having joined the appellant as a party to the petition, he elected not to serve the said petition on the appellant, and further elected to abandon the suit altogether. In finding that there was a preliminary issue to be determined as to whether the appellant could be sued in his personal capacity and not as the President of the Republic of Kenya, in spite of the fact that the appellant was not a party to the proceedings before the court at the election of the petitioners. In finding that the appellant neither entered appearance in the proceedings nor filed any grounds of objection or a replying affidavit, and in proceeding to hear and determine issues that had already been heard and determined by a competent court of concurrent jurisdiction in the matter of Third Way Alliance Kenya and another versus the head of the public service, Joseph Kinyua and 2 others, and Martin Kimani and 15 others in 2020 EKLR. The appellant further stated that the learned judges erred in making a declaration that he had contravened Chapter 6 of the Constitution by initiating and promoting constitutional amendment process under Article 257 by failing to by failing to appreciate the scope and extent of the constitutional doctrine of presidential immunity granted by Article 143 in light of the constitutional mandate and the obligations imposed on the office of the President by Articles 131 and 132 of the Constitution. In finding the appellant acting as the President of the Republic of Kenya can be sued in a civil court in his personal capacity during his tenure of office, and by failing to adopt a holistic and contextual interpretation of the constitutional provisions regarding the powers and exercise of presidential authority to meet our constitutional aspirations and values. There were also three cross appeals that were filed by the 15th respondent, that is the Kenya National Union of Nurses, the 72nd respondent, that is 254 Hope, and the 76th respondent, Mr. Omurara Omoke. The 15th respondent's cross appeal was premised on 6 grounds, and I'll briefly state them. A, that the learned judges of the High Court erred in 1, ignoring, misapprehending, and misconstruing the doctrine of stare decisis and the stability of the common law. B, in failing to appreciate the petitioner's claim before the trial court on abuse of power, lack of public participation, and breach of legitimate expectation by the BBI task force as against the 15th respondent. C, in finding that the 15th respondent's petition for an independent health service commission was unmerited and could not be admitted for inclusion as a constitutional amendment. D, in failing to take judicial notice of the state of health care in the Republic of Kenya. E, in failing to consider and understand the claim before them and the written and oral arguments in support. F, in dismissing the claim before them after holding a contra review that the respondents in the petition had produced no evidence that there were contrary views to its proposals on constitutional amendments that were adopted in the first BBI report, and which recommendations were illegally left out of the Constitution Amendment Bill. The 72nd respondent, that is 254 Hope, raised 4 grounds of appeal, stating that the learned judges erred in failing to find that where the national executive or any of its task forces makes proposals, including legislative proposals and proposals to amend the Constitution, such proposals are subject to Article 47 of the Constitution. 2, in failing to find that the proposals to amend the Constitution for the failure to meet the threshold of rationality, justifiable reasons for the amendments connected to the stated purpose of the amendments and unreasonableness. 3, in ignoring that when the national executive or any government agency proposes to amend the Constitution, it is subject to a culture of justification through cogent and constitutionally sanctioned reasons in accordance with the Fair Administrative Actions Act. And lastly, in failing to find that there was a violation or at least a threatened violation of the prudent use of public resources, including human resources and funds, when the national executive initiated the amendments of the Constitution. The 76th respondent challenged parts of the decision of the High Court by raising the following grounds of appeal. A, that the learned judges erred in law by declining the prayer for an order that President Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by him through the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report, despite making the findings that he had no constitutional mandate to initiate constitutional amendment through popular initiative, and that he violated the provisions of Chapter 6 of the Constitution. B, by declining to order the Auditor General to establish the amount of public funds utilized in the promotion of the Constitution of Kenya Amendment Bill 2020. C, by declining to order President Uhuru Kenyatta, Honorable Raila Odinga, and the BBI Steering Committee to publish or cause to be published details of the budget and public funds allocated and utilized in promoting the impugned bill. D, by omitting to make a finding that the illegal authorization or use of public funds to initiate and promote the impugned bill by the President in the midst of the COVID-19 pandemic contravened Articles 10 and 201 of the Constitution. E, by omitting to take judicial notice of the huge amount of public funds, including a 4 billion car grant to MCAs who had assisted the President in promoting the Constitution amendment through the Building Bridges initiative, and that the surge in the incidence of COVID-19 associated with political rallies led by President Uhuru Muigai Kenyatta and the Honorable Raila Odinga to popularize the impugned bill has had an adverse effect on the people's right to the highest attainable standards of health, and that in view of the said issues, the prioritization of the constitutional amendments through the impugned bill was in violation of the state's obligations under Article 43 of the Constitution. F, by omitting to declare sections 32, 33, 37B, 39, 41, and 44 of the impugned bill unconstitutional. G, by declining to find and hold that the Parliament had no legal or constitutional capacity to debate and or approve the impugned bill in view of the advice of the Chief Justice, retired David Maraga, to President Uhuru Muigai Kenyatta to dissolve Parliament. And G, by relying on ongoing frivolous litigation as a basis for declining to order President Uhuru Muigai Kenyatta to dissolve Parliament in accordance with the advice of the Chief Justice, retired David Maraga. Thank you. I'll stop at that, and Justice Tuyot shall now begin to read a part of his judgment. I'll come back later.
Thank you, Mr. President. Good morning. I choose to read just two portions of my decision. I'll start with the question of the basic structure and its application to Kenya. The basic structure doctrine prescribes that notwithstanding the absence of explicit limitations on the constitutional amendment power, there are implied constitutional limitations which guard against amendments that change the basic structure or identity of a constitution. A matter that dominated this appeal is whether the doctrine is applicable to the Constitution of Kenya. I've had the advantage of reading the draft judgments of the President of this court and my brother, Justice Kiage, on this highly contested matter, and I'm substantially in agreement with their analyses and conclusions. I propose, however, to weigh in on the proposition that the doctrine should be rejected solely for the reason that had the framers of the Constitution intended this category of limitation to be part of our law, then it should have found explicit expression in the text of the Constitution. Another matter that I shall reflect on is what constitutes the basic structure in our Constitution. The appellates argue that to hold that the basic structure doctrine applies to the Constitution of Kenya is to impose an additional hurdle to an already onerous mechanism for constitutional amendment, it being asserted that the provisions of Chapter 16 are sufficiently onerous and have failed at least 19 attempts to change the Constitution. We were urged to adopt interpretive coordinates to reach an outcome that contradicts express substantive provisions of the Constitution. The clarion call on this side of the divide was that this court should not endorse an extra constitutional mechanism for amending our Constitution. The answer to these arguments, and accepted by my brother Justice Kiage, is that fundamental alterations to the core of the Constitution requires the exercise of primary constituent power of the people, which exists notwithstanding non-codification, and that an insistence that it should be expressly provided by the Constitution is an antithesis of the very concept that it is a power which exists in spite of the Constitution, and to provide for it is superfluous. It is common ground that the interpretation of the Constitution is influenced by both text and context. And in this regard, there is the Supreme Court of India decision in the Reserve Bank versus India versus Peerless General Finance and Investment Company, where the court said interpretation must depend on text and context. They are the basis of interpretation. One may well say that if the text is texture, context is what gives the color. Neither can be ignored. Both are important. That interpretation is best which makes the textual interpretation match the contextual. A history of the making of the current Constitution gives color to the text of the provisions of Chapter 16 on amendments. After making significant strides towards the making of a new Constitution, the Bomas initiative encountered a legal challenge presented in the Njoya and 6 others versus Attorney General and another. In those proceedings, the applicant inter alia sought a declaration that certain provisions of the Constitution of Kenya Review Act, which was the legal framework for the Bomas process, transferred, diluted, and vitiated the constituent power of the people of Kenya to adopt a new constitution. Ringera J., who was in the majority, took the following view, and I have set out his view. You would be familiar with it because it has been quoted extensively by parties here. Then the judge makes this important holding towards the end of his decision. From what I have stated so far, it should be manifestly clear that the bane of the Act is the inherent presumption that the making of a new constitution could be accommodated within the power of Parliament to alter the Constitution. As demonstrated herein, the two are entirely different processes requiring the exercise of different powers. The former requires the exercise of people's constituent power, and the latter requires the exercise of Parliament's limited amendment power. The essence of that decision was that the making of a new constitution could only be through the exercise of people's constituent power perfected in a referendum. So as to conform with that decision, the Constitution of Kenya Review Act was amended to provide for a mandatory referendum to ratify a new constitution. All this while, however, Section 47 of the repealed Constitution still read that, and I have quoted it, that it was only Parliament which could alter the Constitution. I will not read those provisions. As things stood, there was now a mechanism provided by statute for adoption of a new constitution after the exercise of people's constituent power in a referendum, but which mechanism was not contemplated by Section 47 of the repealed Constitution. In the run-up to the proposed referendum, the process faced yet another hurdle. In Nairobi Miscellaneous Civil Application number 677, Onyango and 12 others versus Attorney General and 2 others. An issue that arose in those proceedings, and which is not without considerable importance to the matter at hand, was whether a new constitution could validly come into being without an amendment to Section 47 of the existing constitution to provide for the making of a new constitution. In the lengthy submissions before us regarding the doctrine of basic structure and its place, the decision of Onyango and others was not cited at all and appears to me to be the unsung opinion in the jurisprudence around this question in Kenya. The three-judge bench of the High Court, consisting of Justices Nyamu, Wendo, and Emukule, observed as follows. However, the exercise of legislative power and the distinction as outlined above is not applicable to the making of a new constitution by a constituent assembly or referendum because constituent power is not subject to the restraints of any external authority. In other words, the constituent power to frame a constitution is unfettered by any external restrictions and is a plenary law-making power. The power to frame a constitution is a primary power, whereas the power to amend a rigid constitution is a derivative power, since it is derived from the constitution and is subject to the limitations imposed by the prescribed procedure under the constitution. And in answer to the very specific question that was posed, whether the constituent power of the people needed to be textualized, the judges were emphatic. And this is what they said. It has been argued that for a valid new constitution to come into being, Section 47 of the existing constitution should be amended to provide for the making of a new constitution. This court does not regard this as good constitutional law or good constitutional justice. First, we have agreed with the holding in Joya that Section 47 does not deal with the making of a new constitution or the process of making a new constitution. The power to make a new constitution was not vested in Parliament. It is the amending power that is vested in Parliament, subject to the special procedures concerning the entrenched provisions and also subject to the doctrine of the basic structure. We must also add that Parliament has no right to alter the basic structure of the Constitution. I'll invite you to look at that decision in extension. 6 days after the Onyango decision, on the 25th of November 2005, the proposed new constitution was put to vote but was rejected by the people in a referendum. Important for the discussion at hand is that there was an attempt to replace the constitution by the people exercising their constituent power, notwithstanding that the power was not expressly provided by the constitution sought to be replaced. A recognition, in my view, that the power was not subject to limitations or restrictions prescribed by the written word of the Constitution. A fresh impetus to replace the Constitution came after the post-election violence of 2007-2008. In this renewed initiative, Parliament enacted two cardinal legislations: the Constitution of Kenya Review Act, that is 2008, and the Constitution of Kenya Amendment Act 2008. The latter act then introduced Section 47 to the then existing Constitution, and so it made provisions on the replacement of the Constitution. I have set out the provisions of Section 47A of the old Constitution. This new section entrenched a mechanism for replacement of the Constitution and expressly provided that the sovereign right to replace the existing Constitution with a new Constitution vested collectively in the people of Kenya and was exercisable by them through a referendum. For the first time, therefore, the constituent power of the people had found itself in the text of the Constitution. Against this backdrop, another referendum was conducted on the 4th of August 2010, giving birth to the Constitution of Kenya 2010. Admittedly, the new Constitution was created in the context where the constituent power of the people to replace their own Constitution had been codified in the Constitution that was to be replaced. What then are the lessons to draw from this journey? First, is that the 2005 and 2010 referendums are a testimony that the people of Kenya embraced and adopted a constitutional making concept in which the sovereign right to replace the Constitution vested in the people of Kenya, exercisable through a referendum. The exercise of constituent power in 2005 had received judicial nod in the decisions of Njoya and Onyango, while that in the 2010 referendum was codified through an amendment to the existing constitution. The concept is therefore neither alien nor a foreign notion to Kenya. It is very much part of us. Second, and this is the second lesson, the 2005 experience tells us that the constituent power is unfettered and unlimited, notwithstanding that it is not textualized in the Constitution to be replaced. I therefore align to the view that while codifying the constituent power is good constitutional practice, failure to do so neither takes away nor weakens the force of that power. In other words, textualizing it, though a bonus, is superfluous and unnecessary. And this is an invaluable part of the context of the history of our constitution-making offers. Let me now turn to the text, because I must compare the text and the context. In doing so, it has to be remembered that, as correctly pointed out by the Attorney General, Njoya was decided against the backdrop of making of a new constitution altogether. Should it be any different in circumstances not involving the replacement of the constitution, but in regard to its amendment? The respondents to this question invite this court to approach it from the perspective that the basic structure doctrine protects the Constitution against constitutional dismemberment and replacement disguised as amendments. I start by noting that the provisions of Chapter 16 makes reference to the word amendment of the Constitution. Neither in the chapter nor elsewhere in the Constitution is the word amendment defined. And the Interpretation and General Provisions Act, Chapter 2, is not helpful because by dint of Section 2, the provisions of that statute do not apply in or to the construction or interpretation of the Constitution. Turning elsewhere, Black's Law Dictionary, the 10th edition, defines amendment as follows: a formal and usually minor revision or addition proposed, made to a statute, constitution, pleading, order, or other instrument. This can then be contrasted with what a repeal or abrogation is. A repeal is abrogation of an existing law by express legislative act. Express repeal is repeal by specified declaration in a new statute or main motion. Abrogation is the abolition or repeal of a law, custom, institution, and the like. Now, to be inferred from these definitions is that unless otherwise expressed by a constitution itself, an amendment entails a minor revision, alteration, or addition to the Constitution, but which nevertheless does not destroy the Constitution being amended. It does not extend to abrogation, complete repeal, or replacement of the Constitution. In this regard is the work of Richard Albert in his text, Constitutional Amendments, Making, Breaking, and Changing Constitution, where he makes a distinction between amendment and dismemberment. He takes a view that constitutional dismemberments are transformative changes with consequences far greater than amendments. They do violence to the existing Constitution, whether by remaking the Constitution's identity, repealing or reworking the fundamental right, or destroying and rebuilding a central structure pillar of the Constitution. A constitutional dismemberment can both enhance or weaken democracy depending on what in the existing Constitution is dismembered. It is incompatible with the existing framework of the Constitution because it seeks to achieve a conflicting purpose. So in truth, the purpose and effect of constitutional dismemberments are the same as to unmake a constitution. So, for example, in our context, an amendment to transfer judicial authority from the judiciary and independent tribunals to the executive is to unmake the Constitution, as it fundamentally alters a central feature of the Constitution. An amendment is not as drastic because, properly defined, it keeps the altered Constitution in unison with its pre-change identity, rights, and structure. I then refer to Article 255(1). Now, it does seem to me that the provisions of Article 255(1) simply provide for an amendment, and anything that goes further than an amendment must be sanctioned by the exercise of primary constituent power. The provisions of Article 255(1) and the popular initiative were made against the backdrop that the making and unmaking of the Constitution is a preserve of the people exercising their primary constituent power. A change that derogates from the core character of the Constitution is not a change in unity with the Constitution, but one that defaces it. That change, too, is one that can only be made by the people organized in and exercising their primary constituent power. By falling short of making provisions and procedure for unmaking or repeal or reenactment or abrogation of the Constitution, a textual reading of Article 255(1), in my view, matches or is in accord with the Constitution contextual interpretation of the clause that the people to make such change, that the power to make such change rests elsewhere in the primary constituent power of the people and need not be codified. Let me then turn on what constitutes basic structure of our Constitution. This is what the High Court rendered itself. And I read, while the basic structure cannot be altered, I think I'll skip that, but just emphasize that there was a controversy on their finding that whether a particular clause in a constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution. That is what I turn to interrogate. The appellants criticize the findings and argue that the High Court failed to identify the said clauses and provide any objective criteria for such identification. It is submitted that in the absence of clarity, no amendment could be effected without first seeking the court's interpretation, clarification, and concurrence on which provisions are amendable. This therefore will be left to the subjective opinions of the individual judges. A common thread running through the Bomas draft constitution, the WACO draft constitution, the revised harmonized draft, and the proposed draft constitution is the provision for amendment of the Constitution by popular initiative. The rationale for this amendment process, captured in the final report of the recommendations by the CKRC report, as regards the issue of constitutional supremacy, was that the new Constitution should have some entrenched provisions which Parliament would have power to amend without first seeking the views of the people at referendum. Under the scheme of the various constitutional proposals, a distinction was drawn between entrenched and non-entrenched provisions of the Constitution. The entrenched provisions are those that the people felt were the core values and provisions of the Constitution and therefore needed to be barricaded by a special amendment mechanism in which the seal of approval by people exercising their constituent power was mandatory. Notably, the entrenched provisions in the various drafts were substantially the same. In the Bomas draft, they were in respect to the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the principles and values of the Republic, the Bills of Rights, the term of the office of the President, the independence of the judiciary and constitutional commissions, the functions of Parliament, the values and principles of devolution, and the provisions of the amending chapter. The WACO draft retained the same list, save for a small change in regard to the devolution. The entrenched provisions in the latter harmonized draft and the revised harmonized draft are almost forward those in the Bomas and WACO drafts. They again found their way into the protective provisions of Article 255(1) of the 2010 Constitution. It is a list that survived changes made in the various draft constitutions. It is testimony that the people meant what they said and were clear as to what they considered to be the essential features of the Constitution. It is a list to be revered and cannot be shortened or lengthened by judicial interpretation or craft. It matters not that in the mind of a judge, the list is either too limiting or too extensive. To be deduced is that if the people of Kenya felt so strongly that the provisions relating to the matters listed in clause 255(1) needed protection from indiscriminate amendment, then even more so, those are the very provisions which should not be abrogated or replaced without the exercise of the people's constituent power. In my view, what comprises the basic structure of the Constitution is therefore specifically defined by the people of Kenya, and there are those in Article 255(1) which, even in amendment, require the exercise of constituent power, and that is the secondary power, constituent power. That said, the true concept of the basic structure in the Kenyan Constitution becomes clearer still by looking more closely at the words of Article 255(1). They require compliance of Article 257 for an amendment that relates to the matters listed in Article 255(1). Save for reference to Chapter 16 and Articles 10, the articles of the Constitution to be protected are not specifically set out. Instead, they are identified by theme. And this makes a difference. What comprises the basic structure is what is in respect to those thematic matters. So, for example, matters on the sovereignty of the people, which power, by dint of Article 3, is delegated to the three distinct arms of government, extends the protection to the doctrine of separation of power. So, while the doctrine of separation of power is not directly mentioned in Article 255(1), it is part of the basic structure of our Constitution, as it is a subset of the wider design on how the Constitution has organized and structured the exercise of sovereign power. I take a view that what comprises the basic structure of our Constitution is therefore easily identifiable. But should a need for judicial inquiry arise as to whether a matter is part of the basic structure of our Constitution, then that inquiry will not be rudderless, neither will it be an unguided exercise, because it is firmly beaconed in Article 255(1). So those are my short views on the question of the basic structure and its breadth. I then turn to the question of the Iebc quorum. In deference to Section 8 of the Iebc Act, the second schedule to the Act makes provisions as to the conduct of the business and affairs of the Commission. The schedule underwent some amendments through Act Number 1 of 2017. In respect to the quorum of the Commission, the amendment reduced it from 5 to 3 in the following words: the quorum for the conduct of the business at the meeting of the Commission shall be at least half of the existing members of the Commission, provided that the quorum shall not be less than 3 members. The amendment was not without controversy and was the subject of a constitutional challenge in Katiba Institute and 3 others versus the Attorney General. In a decision rendered on the 6th of April 2018, Muita J declared the new provision unconstitutional. In the impugned judgment, the High Court judges proceed on the assumption that the latter provision requiring a quorum of not less than 5 was the existing provision. The judges do so without ambiguity in paragraph 702 of their decision, which I have set out. The argument by IEBC is that while the decision in Katiba had the effect of declaring the new paragraph 5 of the second schedule unconstitutional, the decision did not revive the older provision, and so, as it now stands, there is no statutory provision on the quorum of the Commission. What would be the legal effect of the above declaration? Cited by IEBC is the decision of the Supreme Court in Mary Wambui versus Gishuki Kingara, in which the court had occasion to consider the effect of a court's declaration of invalidity of a statute or provision within it. I have set out what the Supreme Court said. Clearly, the true effect of such a declaration can only be gleaned from the declaration itself. The court may make the declaration retrospective from the date of enactment of the offending provisions or statute. The court may choose to limit the retrospective effect of such declaration or even to suspend it to a future date. And as held by the Supreme Court in Mary Wambui, whether the effect ought to be retroactive and or proactive depends on a case-to-case basis. So, for example, in petition number 413 of 2016, Boniface Oduor versus the Attorney General, the High Court, after declaring sections 33B1 and 33B2 of the Banking Act to be constitutional, suspended the declaration for 12 months from the date of the decision. Where, however, a declaration by the court is silent as to when it shall take effect, the date of the declaration is deemed to be the date of effect. In Katiba Institute, Justice Muita declared paragraph 5 of the second schedule, amongst other provisions, to be constitutionally invalid without more. The judge neither limited the retrospective effect of the declaration nor suspended it. To be inferred, therefore, is that the declaration operated retrospectively to the date of the enactment of the provision. The repercussion of the declaration was that the amendment of paragraph 5 of the second schedule to the Act, which was introduced by the Elections Laws Amendment Act number 34 of 27, was constitutionally void. Under the Interpretation and General Provisions Act, to amend means to repeal, revoke, rescind, cancel, replace, add to or vary, or the doing of any two or more of those things simultaneously on the same written law or instrument. Amendment of a statute is a legislative act, and while it is open to a court to declare an amendment to be constitutionally void, the declaration does not revive the former provision, just as it does not repeal or annul a provision it has declared to be constitutionally invalid. The former provision would have to be revived by legislation, a preserve of the lawmaking body. And in this regard, I have quoted a Supreme Court decision from India. And although not having a direct bearing to the matter at hand, one would perhaps draw parallels from Section 20 of the Interpretation and General Provisions Act. So, in my view, revival of a previous provision of statute has to be the work of legislative craft and cannot be implied or derived from the judicial pronouncement of the unconstitutionality of the amending provision. And let me explain why I am attracted to this proposition. Take an instance where a declaration of an invalidity of an amendment by the High Court is not challenged on appeal. If it were to be construed that the court's pronouncement amounts to automatically reviving the amended provision, then even courts of a higher rank will be bound by that revival, notwithstanding that such a court would be of a view that the declaration was made by incuriam. This is because the declaration will have removed the amendment from statute. If, however, it is taken that the High Court declaration is simply a pronouncement that the amendment is in conflict with the Constitution and therefore void and inapplicable to the rights of the parties before it, then a court of coordinate or higher jurisdiction is free to arrive at a different decision in another matter because the amendment will still exist in statute. This latter position is perhaps the better position in a jurisdiction like ours, where there is no requirement that every declaration of unconstitutionality of a statute or provision must be tested and affirmed by the apex court. Given my appreciation of the law, I would reach an outcome that although the effect of the decision in Katiba Institute and another was to render the new provisions of paragraph 5 to be ineffective and a nullity, the decision did not revive the former provisions. The argument that the High Court relied on an existing provision of statute is therefore, in my view, with some merit. Yet, as I shall be proposing in due course, in interrogating the question of quorum of Iebc, the trial court was obliged to reach an outcome that was aligned to the expectations of both the Constitution and the Iebc Act. Simply, the court was not handicapped in resolving the matter because the Constitution, read in conjunction with the Iebc Act, provides a clear answer to the question. Next is whether the decision of the High Court in Isaac v. Watt in regard to the issue of quorum was a decision in rem, and if so, whether the High Court was bound by it. The court in Isaiah v. Watt was not called upon to declare the composition of Iebc illegal or unconstitutional as a result of the resignation of 4 of its commissioners. Was not only called, let me take that again, the court in Isaiah v. Watt was not only called upon to declare that the composition of Iebc was illegal and unconstitutional as a result of the resignation of 4 of its members, but also invited to declare that as composed at that time, Iebc lacked quorum to conduct or carry out the business. You would be familiar with that decision. Iebc is a constitutional commission established under Article 88 of the Constitution. The pronouncement by the court in Isaiah v. Watt as to the constitutionality of its composition and quorum was without doubt a pronouncement made in public law and a judgment in rem in regard to the two issues. And I identify with the holding in Ems versus Queen that if a formal declaration of invalidity of administrative regulation is not considered effective towards all those who are subject to it, it may mean that to all other persons concerned with the application of the regulation, including subordinate administrative agencies, have to keep on giving effect to what has been declared a nullity. It is obvious, for the purpose of avoiding this undesirable consequence, that in municipal law, the quashing of a bylaw is held to be in rem. I close the quote. So one would be sympathetic if Iebc were, on the strength of the Isaiah v. Watt decision, take comfort as to its quorum. Yet for now, the more decisive issue is whether the pronouncement in rem could bind a court of coordinate jurisdiction. Stated more boldly is the question, is the stare decisis doctrine to be suspended when a judgment is in rem so that the precedent binds a court of equal rank. I do not consider this to be a matter of small importance, not in the least because of the passionate argument by counsel for Iebc that inconsistency of pronouncement of courts in areas of public law confuses members of the public as to what the law is and is a recipe for judicial anarchy and mayhem in public law. Fortunately, other jurisdictions have had to grapple with similar predicament. Faced with the question whether a court was bound to follow the declaration of unconstitutionality of a statute by another court of coordinate jurisdiction is a view taken by a judge in Canada in the case of R versus Sullivan, which I will invite you to read and which I have quoted. This is what I draw from that decision. The importance of having consistency in the application of the law, particularly in matters touching on the public, cannot be minimized. Both the public and persons or bodies charged with carrying out public functions should be able to tell without difficulty or hesitation whether their actions or conduct passes legal or constitutional muster. To hold that a public body is properly and legally constituted today and to say otherwise the next day may not be good for public administration. So there is much to be gained in legal stability. There is much to be gained in the legal stability that is brought by stare decisis, the stare decisis doctrine. Yet, that has to be put on a scale against the effect of foreclosing another court of coordinate rank from relooking at the same question in a different matter where forceful arguments are made as to the correctness of the earlier decision. Not to allow a revisit would be to stifle judicial debate in an area that may well be unsettled, and in the process to stunt the growth of jurisprudence. It may well be to allow a matter that has been wrongly decided to take root and to perpetuate itself. So as to strike a balance, the doctrine of stare decisis, even in public law, should not apply any different, but a latter court should be reluctant to open a matter already pronounced in rem by a court of coordinate jurisdiction unless there is compelling reason to believe that the outcome is different. In addition, I suggest the Attorney General or the public body affected, if not parties, should always be invited to express themselves on the matter before the court renders itself, so that the matter can have the full benefit of arguments on the subject. Lastly, if the earlier decision is on appeal, then the latter court should await the decision, the outcome of the appeal. Let me now return to the circumstances of the decision of Isaiah B. Watt. And this was not challenged, and I have therefore to examine whether the High Court was justified in departing from it. I have set out that Iebc is established by Article 88(1). It is a commission to which Chapter 15 of the Constitution applies. The Constitution does not require enactment of legislation to fix the exact composition of Chapter 15 commissions. However, Article 88 of the Constitution provides as follows in respect to the Iebc. The Commission shall exercise its powers and perform its functions in accordance with this Constitution and national legislation. I would take it that this provision gives national legislation sufficient latitude to fix the number of members of the Commission, as long as it is within the range that is provided in Article 251 of the Constitution, and also to fix its quorum for purposes of effectively discharging its mandate. In its preamble, the Iebc Act declares itself to be an act of Parliament to make provision for the appointment and effective operation of Iebc and for connected purposes. Subsection 1 ordains the Commission shall consist of a chairperson. This is subsection 1 of Section 6, that the Commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution and the provisions of the Act. While the Constitution does not fix the exact composition of IEBC and only provides a range of not less than 3 and not more than 9, statute fixes the composition to be 7. None of the parties suggest that national statute on the composition of IEBC is unconstitutional. And insofar as it does not breach the constitutional range, there will be little merit in an argument that Section 5.1 abridges the Constitution. The statutory composition of IEBC is therefore 7. And as to why Parliament settled on 7, the High Court suggested the Constitution placed the minimum number of the commissioners of the Independent Commission at 3 and the highest number at 9. Parliament, while appreciating the important mandate the IEBC discharges, picked a high number of 7 commissioners to constitute and placed its quorum at 5 members. Close quotes. That is a view I endorse. IEBC gallantly pressed the position that a quorum should be examined against the constitutional contemplation that the composition of the commission should be 3, could be 3, and if so, the number of commissioners, and if the number of commissioners had fallen to 3, as had at the time material to the petition, then a quorum of 3 met the threshold. I'm afraid I'm unable to agree with the argument by IEBC. Whilst the statute has fixed 7 as the membership of IEBC, it contemplated that death, resignation, or other reasons could cause the actual membership to fall below the statutory number. Given the important constitutional mandate of IEBC, which includes conducting by-elections and referendum, whose timing is unpredictable, the IEBC Act has a robust mechanism for promptly filling of any vacancies. And I've quoted Section 7 of the Act. These provisions speak to the urgency in which the recruitment process must be commenced and completed. Paragraphs 1, 3, and 4 of the first schedule to the statute, which elaborates on the procedure for appointment of the chairperson and members, gives short timelines as a restatement of the speed within which the vacancies must be filled. I have set out those provisions. The scheme of the statute and the regulations is that by providing for prompt mechanism for filling vacancies, then at all times and as much as possible, IEBC should be in its full complement of members. A recognition that given its important constitutional mandate, IEBC should carry out its functions with all hands on deck. To allow the quorum of the Commission to oscillate with the actual number of members at any time would be to countenance a possibility that for as long as the numbers do not fall below 3, then the appointing authority need not promptly or at all trigger the process of filling the vacancies. The membership of IEBC could then suffer want of gender parity or regional or ethnic diversity that is required by Article 254. Drastically reduced membership could lead to a crunch in confidence by members of the public as to the Commission's ability to be independent and truly neutral. The quorum question must therefore be answered against this broader constitution and statutory imperative. And it yields an easy answer, that the quorum of IEBC must be seen against the full composition of 7 required by the IEBC Act. And so I'm aligned with the rationale of the decision of Justice Mwita and Katiba Institute. In conclusion, on that question, the effect of the decision was to sustain the quorum at 5 or at least 4. To hold that the quorum could be anything less than half of the membership of 7 is to weaken the Commission. It is common ground that IEBC formulated administrative procedures to guide on the verification of signatures in support of a constitutional amendment, There can be little doubt that formulation of such guidelines will be the business of the Commission given the critical importance of that threshold in a popular initiative process, and the Commission needed to be quorate. So following a slightly different route, I reached the same decision as the High Court, that IEBC was not quorate when it embarked on the business of verifying the BBI signatures on membership of only 3. So thank you. I'll invite the parties and counsel to read the rest of my decision. Thank you, Mr. President.
Thank you, my brother Justice Tuyot. The Honorable Justice Charlie will now read another part.
Thank you, Mr. President.
Sorry, my sister.
Yes.
I realize it is just about 11, and we had indicated that we'll adjourn, take a short health break at 11. I propose instead of my sister starting, and then we have to adjourn in between. We take a short health break now, and we turn, and then the Honorable Lady Justice Charlie will read our judgment. Thank you.
Kuni igoti-inĩ rĩa gũcokia cira riko na ũjaji ũrĩa ũkwaragĩrĩria kana ũkũrutaga itua rĩake nĩ jaji Tuyot. Jaji Tuyot ũrĩa warĩkia kuga atĩ kũringana nake atĩ andũ arĩa maendwo mathathaũre kana IEBC ĩkĩrwo ĩthathaũre signatures iria cionganĩtio nĩ ũndũ wa BBI ndĩakinyanĩirie kana quorum ĩrĩa tũngiuga quorum nĩ igatĩwe nĩ ĩtĩkania atĩ na itua rĩa igoti rĩrĩa rĩatuĩte kana High Court ĩrĩa yatuĩte atĩ IEBC ndĩakinyanĩirie quorum ya kũhota gũtua kana kũrora signature icio ciothe. Ũcio nĩ jaji wa mbere wamba kwaria. Ririkana mũthenya wa ũmũthĩ nĩguo cira ũrĩa ũcoketio igoti-inĩ kana cira wa gũcokia cira riko ũgũkorwo ũgĩthiĩ na mbere, na nĩwona mambĩrĩirie o rũcinĩ thaa 3 macoka makĩrwo thaa 5 nĩ megũkorwo kana makĩamba kũhurũka hanini na mamba gũikĩria macokererie ningĩ thaa 5 gũra kĩndũ na nuthu na megũkorwo magĩthiĩ na mbere na kũruta o majaji jaji araheo kahinda. Tarĩ ũcio wa mbere nĩ jaji Tuyot ũrĩa warĩrĩria ũhoro wa IEBC. O jaji nĩ ũkorwo na kĩrĩa ũkorwo akĩrora nĩ jaji othe mũgwanja mũndũ ũkorwo akĩruta itua rĩake nĩgetha tũkĩgũre gũgũthiĩ. Ririkana no magĩcoka mahuruke ningĩ ithaa rĩa thaa mũgwanja, koguo jaji ũrĩa gũcoka wa kerĩ nĩ ũkorwo agĩtwĩra no nĩguo wa mbere kĩrĩa akorwo aria ũhoro wa IEBC nĩ kwari na itua rĩa IEBC gwĩtuĩka atĩ IEBC ndĩakinyanĩirie ikĩro cia gũkorwo ĩkĩrora signatures iria kana thaĩri iria iria cionganĩtio nĩ andũ arĩa makoragwo makĩandĩkithia mũbango wa kũgarũra watho kũgerera BBI. Koguo tũkorwo tũkĩrora we nĩetĩkania na andũ acio atĩ IEBC ndĩakinyĩtie kana ndĩakinyanĩirie ũrĩa yarĩ kana ũrĩa yombĩtwo ndĩakinyanĩirie gũhota gũtua itua. Tarĩ tũcokereria nĩ gũkũmenyithia maingĩ na tũkorwo tũkinyarĩra na mwandĩki wa mohoro gwĩtwo Gathoni wa Njihe nĩgetha atũmenyithie mamwe ma marĩa marahanĩka tondũ nĩwe wĩ hau kana igoti-inĩ rĩu rĩa gũcokia cira riko. Twambe tũikĩrie.